always subject to. Now, the Acts Interpretation Act 1901 Commonwealth also says in section 15A, every law
what section did you want?
Is subject to the Commonwealth Constitution.
15.
15.
What about the fact that it states very clearly that every court case, every that is conducted, there is a higher law that must be acknowledged. Are you aware of that?
Yeah, pity they don't adhere to it.
Yeah. That's the biggest backing we've got as to the strength of our Constitution.
Absolutely, but they're ignoring our Constitution.
Well, yeah, if the judge is just ignoring the Constitution,
15 up there.
then it's not a hearing of justice.
That's right.
So the real question is how do you get them to actually look at that and take that on? That's really what this is.
Well, we do this by, unless this is done, then we remove our consent. Now, I've been removing my consent for over 10 years. I've lost count of the amount of times they've thrown me in court over a number of issues, and they haven't followed me. Okay. So it is powerful. They do make rulings saying otherwise. Oh yeah, well we don't care about that, Mr. O'Brien. Too bad. We're just going to rule against you anyway. And you know, I've racked up thousands and thousands of dollars worth of fines, but they don't follow.
Can you go after the judges?
Sorry.
Can you go after the judges?
Yeah, I've sent one of the judges. I tried to stop the dredging in Port Phillip Bay along with 2 others a few years ago, and we were just treated like rubbish. It shocked the media actually. They'd never seen judges or courts acting this way, and even the state solicitors and barristers were shocked at the behaviour of the judge, and they followed us out and sort of trying to get comment, and very quickly the interviewer was told to back off, go away. And as a result of that, I served what was called a bill of exchange on the judge, saying that I'm fining you under English law. It was quite a lengthy document, probably about 30 or 40 pages long, but to someone in his position, he understood what it was about. And it was a way that was established back in King Henry VIII's time to bring about justice when you've been done wrong by the courts.
Is that for the Queen's Bench?
Yeah, the King or Queen's Bench, yeah.
And that's not counted as defective administration, per se?
Yeah, it's under the law of tort. T-O-R-T.
So you can take any public servant to the Queen's Bench?
Absolutely. No public servant can hide behind their corporation identity.
And they're all
liable as individuals.
Well, what happens if they're a corporation?
Well, the corporation, it's two-tiered. The corporation can be taken in under sections 4B and 4K of the Crimes Act, Commonwealth 1914, and basically that means that because you can't physically take a corporation and put them in jail, I wish we could, but that effectively only means that you're taking something equivalent to that.
You can still fight the corporation,
Sorry?
under effective administration, you can still fight the corporation.
Yeah, but to penalise a corporation, you liquidate the penalty. So all statutes and all laws have a penalty clause attached to them. So for instance, if it's a 5-year prison term, then you liquidate that penalty. And it works out the calculations in the Crimes Act under section 4B. And it's a matter, it works out to about $33,000 a year. So we've got a 5-year jail term. Multiply that by 5, that's the penalty to that corporation. And as of 2010, they've actually boosted that because there's up to $10 million fines applicable for any one breach under that Act, for harassment or coercion, for instance. So, but back to the Parliament. If we read section 15 here of the Constitution Act of Victoria, we'll see where the problem lies really. The legislative power of the state of Victoria shall be vested in a Parliament which shall consist of Her Majesty, the Council and the Assembly, as known as the Parliament of Victoria. Now, from what I've just shown you and explained since the start of this meeting, yeah, that's a joke, isn't it?
Darryl,
Total breakdown of the separation of powers.
there is a little explanation to this, and I suppose now would be a good time. That same clause was in the 1855 Constitution, which was Victoria's first constitution, and it should have been brought up into line with the Commonwealth Constitution at the time of Federation, and Victoria did not do that. At the time of Federation, the constitutions of the colony that become a state were to be subject to the Commonwealth Constitution. And not every state, in fact very few states, actually did that. And this is one of the hangovers from that era. Now what I'm saying to you is that that same section 15, it wasn't called 15 in them days, but that same section was in the old 1855 Constitution that Victoria had as a colony, and it come through Federation, was not corrected at the time of Federation as directed by the Commonwealth Constitution 106, and it's still today in the 1975 Constitution. I just thought that might explain things a little bit to people.
What's still in there, that statement about?
It wasn't section 15, I just forget the section it was in the 1855.
But that's the same section.
Word for word.
Yeah, good.
And section 16 is even worse.
Well,
Section.
that's the police swear to Her Majesty.
Yeah.
Oh, that's their allegiance,
That's
it's a different...
quite significant, their oath is to Her Majesty.
Victoria,
Yeah,
State of Victoria withdrew the contract under the Police Statute Act of 1833 and also the Police Regulation Act 1890. They've got their oath, and then under Section 12, they've got their contracts solely to the Queen. In the 1958, they've got their oath.
Okay.
I admit, I forgot.
so we go to section 16.
Sorry, can I talk, what was that in the Constitution that said this graded?
Yeah.
What was that?
Well, section 106 says that all state constitutions are subject to the Commonwealth Constitution. So the Commonwealth Constitution establishes the three entities that make up government.
Is section 109 governed by section 122
Section
in
122,
the Commonwealth Constitution?
that's...
No, they're separate.
Yeah, they are separate. But what's important is to keep in mind that the separation of powers is paramount to the structure of government in this country. There's no excuse to step away from that in any way, shape or form. And there's no way you can blend the executive into the parliament and expect to have no conflict of interest in any way.
If anyone's, sorry Darryl, but if anyone's interested in this separation of powers, there's a document or a book, sorry, called Quick and Garran. Quick and Garran? Sir John Quick and Sir Robert Garran. Back in 1904, I think, it was published first. You can still buy a copy of it today. If anyone brings a memory stick with them, I can dump a copy of it on their memory stick off my computer. And that talks about a separation of power at some detail. Now that document is very valid in any court in the country. Well, that book is a valid evidence to be in any court in the country. And like I said, that goes into the separation of power at considerable lengths. And there's people, High Court, Gleeson, a former High Court judge, he quoted from that at some length, at some of the Boyle lectures and that they done in the year 2000. So it's a well worth document. It's well worthwhile reading that book if you can get hold of it. If anyone wants a copy of it, if they bring along a memory stick, I'm more than happy to dump it on it for them. It is the annotated constitution. Can you? Okay. I've just been told you can download it off the internet. Yeah, it costs you, oh, it was more than that. My copy cost me about $345 at Melbourne University bookshop a couple of years ago. Wasn't I a fool? Quick and Garrett.
Q-U-I-C-K and Garrett.
Annotated Constitution by Quick and Garrett. Quick, Q-U-I-C-K, G-R-R-R, Garrett, G-A-R-R-A-N.
Okay. Now, yes.
How should a maximum of laws stand up against the Constitution?
Well, the maximum law can't conflict the law in any way, shape or form with the Constitution. No. Maxims of law were established under the laws of England as they were consistent with the laws of England. The laws of England are inherited in our Constitution. In fact, to show you the exact section, we'll shoot to section 118. 118 of the Commonwealth Constitution.
Or 109.
118. We want to establish the law of England. Now, while Kelvin's finding that, I mentioned earlier how important it is that you express your will. There is a bookshop in the city called the Heritage Bookshop. It's in Russell Street. I'm not sure of the exact number, but you can buy a copy there of a book called Your Will Be Done by Arthur A. Cresby. And it explains your sovereignty and how to communicate with your elected representatives. Okay? So it's a very good little book. Yes, we have got it on our website, so you can look at it there. Okay, so on the board we've got section 118, recognitions of laws, etc. of states. So full faith and credit. Full faith and credit shall be given.
What does that mean?
Full faith and credit. So there's no doubting. No doubt. Shall be given throughout the Commonwealth to the laws of public acts. So the words the public acts bringing the laws of England. Okay. And records. Now, and records brings in the Hansard of the constitutional debates leading up to Federation, and any Hansard with relation to the making of law. Okay. And judicial proceedings of every state, as long as that judicial proceeding is consistent with the Constitution.
In terms of like the laws, the public acts and records, if you download either the state or the Commonwealth Constitution, do they give definitions to these things, or this is all part of learning?
You get the definitions to this in the Quick and Garrett, what we mentioned earlier. The Quick and Garrett is a history, it's a 1,000-page book documenting the history of those 10 years leading up to Federation, and why each section was brought in, and enforcing and reinforcing each one of those sections. And in fact, section 109 is brilliant. The way they actually interpret section 109, and they foresee the problems that we are going through right now. Okay. Don't think for a second that we've moved forward, because we haven't. We've moved back. We're back in the 19th century, prior Federation, because the states, the courts are just ignoring that this document exists. And in fact, just recently we had a young policeman who was doing his time in the academy say that they were actually instructed but the Commonwealth Constitution has no effect in